To help us break down what's happening with that first part, let's bring in our first guest now. We're talking to Attorney Ruben Carranza, Senior Expert at the International Center for Transitional Justice. Attorney Carranza, thanks so much for being with us. If you are still in New York, then it will be very early your time. Thanks for making time.
You're welcome. Happy to be here.
Okay. You obviously watched that submission on the merits of the case from Attorney Nicholas Kaufman. What were your big takeaways? What did you think?
There was nothing unexpected or even innovative about his presentation. Remember, this is the presentation on the merits, so this is supposed to be in contrast to the opening statement that he made, and so that the expectation should have been that the presentation that he made today on the merits fleshes out and expands on the opening statement. Unfortunately, the defenses he raises are predictably the excuses that Rodrigo Duterte and his co-perpetrators have already stated elsewhere outside of the ICC. But on the other hand, that is understandable because the presumption of innocence means that he need not lay out an explanation for why thousands of people died. But one key thing, he said that the statements of the criminal cooperating witness, in other words, the insider witness that he keeps quoting, together with the statements of Rodrigo Duterte that were also used by the prosecution, he said that these are circumstantial. And he did acknowledge that circumstantial evidence has been used at the ICC in previous cases. Jean-Pierre Bemba, Tomas Lubanga, so, the first case, as well as one of the more recent cases in which, in fact, Kaufman was the lawyer for Jean-Pierre Bemba initially. He did acknowledge that in those cases, the ICC, the trial chamber, accepted circumstantial evidence, but he says that circumstantial evidence in this case, he claims, is low quality, and that there are other conclusions that can be made from the circumstances. I don't know if he will address it in the resumption of this presentation, but the problem is that his problem in defending Duterte is that the outcome is thousands of murders. So you might have other conclusions. They were joking, they were instilling fear, they were planning something else, but then the outcome is thousands of murders. So that, I think, weakens his argument that there are other possible conclusions to make out of these statements.
So his defense, at least in this first part, was predictable and nothing came as a surprise to you. But one thing that struck me is when he said there is no smoking gun in this case. There is not one demonstrable incident that shows that there was direct orders to kill in all of the 49 incidents that the prosecution is using in this case. What did you think of that? I thought that was pretty powerful to say, because that is exactly the question that we're trying to answer here, right? Is there enough grounds? Is there substantial grounds to move this case to trial?
He did sort of make his own interpretation of the persons watching now should remember the characterization of Rodrigo Duterte here is indirect co-perpetrator, which means there are direct co-perpetrators. And as Kaufman mentions it, the ICC uses different modes of liability, meaning different theories of how persons can become criminally liable, can be convicted, can be found guilty. And one of them is the concept of indirect co-perpetration. There are others, and maybe not now is not the time to do it, but joint criminal enterprise, command responsibility. So there are various other theories, modes of liability that the ICC and other international criminal tribunals have used in the past. The One of the important elements of indirect co-perpetration as a mode of liability, as a way of convicting a person, is that there is a common plan, and Kaufman acknowledges that there is, the prosecution has tried to prove that element here. But one of the other important elements is that the direct co-perpetrators, including insider witnesses, including policemen below the other co-perpetrators, the other indirect co-perpetrators, that these are tools, they are weapons, they are ways of accomplishing the criminal common plan. And that's the problem here when he says that that there is no smoking gun. There is no smoking gun with respect to Rodrigo Duterte. Why? Because he is an indirect co-perpetrator. There is a smoking gun with respect to those who actually carried out the killings. There is a literal gun in many of these instances, and he then cites statements that say, "We found guns," for instance, according to an insider witness. And of course, those quotes that he makes are extracted from the overall interviews, and so the ICC judges will, I am sure, look at the entirety of the interviews conducted by the ICC investigators and used by the prosecution, to which everyone has access, by the way, the defense, the prosecutors, obviously, and the judges. But that's the incomplete aspect of Kaufman's argument. There is no smoking gun with respect to Rodrigo Duterte because Rodrigo Duterte is an indirect co-perpetrator. I won't say only, because an indirect co-perpetrator is just as guilty as the direct co-perpetrator in this theory, in this mode of liability concept.
Okay, so you can convict a person based on circumstantial evidence, and there's no smoking gun in this case because he's being charged as an indirect co-perpetrator. Is that a lesser crime than, I suppose, a direct direct perpetrator?
No, it's the same level of liability. He's a principal. I'm trying as hard as I can not to be a lawyer in terms of the language I use here. So he is as guilty as those who shoot and kill. He is as guilty as those who ride motorcycles in tandem and assassinate people who were killed in the drug war. Let us not be misled by the term indirect, because indirect does not lessen liability. Indirect, the use of the word does not mean he is less guilty. If there were to be a hierarchy of guilt, then you could even argue that it should be from the top going down. But the value of this concept of indirect co-perpetrator and direct co-perpetrators executing a common plan is that it's both the conduct, even words, even statements made by the indirect co-perpetrator linked to the outcome, to the conduct, actions, not necessarily words of the direct co-perpetrators, that manifests, that shows that there existed or exists a common plan, and in this case, a common plan to commit crimes against humanity of murder. So, like I said, when Kaufman denies that they had a common plan, when Kaufman denies that there is a smoking gun that can be traced to Rodrigo Duterte, he doesn't account for the fact that thousands of people were then murdered by... If these elements were not connected, Duterte's statements, Bato de la Rosa's own statements, the actions of police, some of them identified, some of them unidentified, that then results in thousands of murders. Are they random? Are they unorganized killings that only happened to take place within a span of a few months to 2 years. They have never happened before in the Philippines. And if they did happen before, they happened in Davao, which, by the way, is part of the initial set of charges.
Yeah.
So there's only one inference you can make from that.
Well, I'll leave that to the judge, sir. Pero yung the 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 point that he was trying to drive at, I guess, is clear. He was trying to cast doubt on that causal link between the speeches and the killings. In his opening remarks, he said, part of the problem, and I'm paraphrasing here, part of the problem is that the Philippine media, the journalists here tend to fixate on the salacious parts of a person's speech and leave out the boring parts. That was pretty accurate in terms of the wording. And he says that relying on the speeches to prove criminal intent is impossible here. What did you think?
No one will ever, unless there's somebody perhaps as convinced of his impunity as Rodrigo Duterte, no one ever comes close to saying, I will, as a government official, I will now order other government officials to commit crimes. That isn't not only not normal, but that isn't how crimes are committed. And even if, as I said, in the case of Rodrigo Duterte, he came close, and not even close, but sometimes actually crossed the boundary between saying something and commanding the commission of the crime. The excuse that he also, in some of his statements, qualified those words with words such as "but follow the rules," or as Kaufman cites here, the memo that was issued by Rodrigo Duterte's government says respect human rights.
Yes.
Those qualifications don't even have to be said. The fact that you say them in a document, even if you did not have to say them, because obviously government officials, the police, are supposed to follow human rights. If you have to put that in a document, if you have to put that in a memorandum called Oplan Double Barrel, that means you are trying to cover up their violations of human rights, because there is no reason, unless you're the Commission of Human Rights, in which case that's your mandate. You say it and you specify it, but there is no reason really to have to say that, unless it was something you already had in mind to use later on as an excuse, as a defense, which unsurprisingly Duterte himself also says. He says, I will protect you. He says, I could even pardon you. He says, I will make sure you are not prosecuted. And that's how he does it, by coming up, for example, with a memorandum that says, you do this. He doesn't say kill. He says neutralize. He doesn't say commit mass murder. He says carry out operations. Because nobody will say in a memo carry out mass murder. Nobody says in a memo kill 1,000, 2,000, 5,000 persons. And again, it goes back to the same question that Kaufman did not address. Why did all of these memos, all of these statements, then were followed by thousands of people killed?
But yun nga, sir, towards the latter part of his argument, Attorney Kaufman was saying the fact that some police officers took to neutralize to mean to kill should not be on Duterte, because he didn't actually say that explicitly. But I guess what you're saying is, there is some sort of a causality there as well, and it's up to the prosecution to prove.
And something to also link to this defense. Neutralize did not mean kill. Duterte did not say that for policemen to interpret it as killing. It's a similar question, really. How does he explain why thousands of people were killed after the word neutralize was used. That is an example of circumstantial evidence. The ICC in past cases, Katanga case, a warlord in the Democratic Republic of the Congo claims he did not issue similar explicit orders, but that his subordinates killed people anyway. In that case, the ICC in fact said that the prosecutor and later on trial judges, if they convict the accused person, that they do not have to explain their logic every step of the way. They do not have to painstakingly explain why they arrived at a certain conclusion. Why? Because inferences are possible. The human brain is capable of sorting through and filtering among different possibilities connected with a term, a set of words, a piece of paper that can be interpreted in different ways, but that if you take all the circumstances together, and an inference is possible, and though no other inferences might be made that explain it, then that can be the basis of a conviction. So, neutralized, and this is the other point here, within the context of the Philippines, neutralize has been applied by law enforcement agencies in the Philippines, not just the police, but even the military, to mean to kill. Kaufman has been fond of excusing Duterte's speeches and conduct as part of the culture. Many of Duterte's own mouthpieces are fond of excusing him by saying he's just Bisaya. He's just speaking in his language back in
Bluster.
Davao. I grew up in Cebu, and I know I speak the language and I understand the context. And so I know what persons who use the language mean when they say something in place of something else. And that's exactly what Duterte is doing here. The swagger, the language, both the body language and the actual words, including in Bisaya, are meant to neutralize the term that policemen in Davao, not just later on, not just nationwide, but in Davao, who understand the same language, who literally speak the same language, they knew neutralize in Bisaya would be pumatay. So,
Oo nga, that's
you cannot have you cannot have one interpretation and say he was just joking, he wasn't serious, and then on the other hand say don't take it out of context. You cannot say don't take his jokes out of context in one hand and then say here take it for the context it is in.
The word that he often uses is bluster. It's just bluster. And you're right, in local context, the word neutralize has always been used in police operations, even way before the war on drugs. But I get your point. Inferences are what it's going to come down to. Inferences are possible. We'll leave that there for now. We'll circle back to you a bit later on in the program. We do have a 4-hour stretch here. But thank you so much for talking to me, Attorney Ruben Carranza, Senior Expert at the International Center for Transitional Justice.